The question as to whether or not SMEs should go to court if they're unhappy with the procurement process, or whether they should sit down with the public body and see where they went wrong, is a difficult one to answer in a general sense, because really it depends on what the SME thinks went wrong. If the SME thinks they didn't get the tender because, for example, their price wasn't low enough, then it seems to me that it would be sensible for them to sit down and go through the tender with the public body. Or, for example, if they didn't meet the pre-qualification criteria, again, it might be sensible for them to go to the public body and talk about how they could improve, let's say, next time. In that circumstance, I don't think it would be appropriate for them to bring their lawyer to the meeting at all, because what they're hoping to establish is a good working relationship with that public body so that in future they can get contracts. If, on the other hand, they think that there has been a flaw in the procedures which were used by the public body, or if there has been some irregularity in the way the contract is awarded, then it seems to me that it is probably more appropriate to approach the matter in a legal fashion and to take whatever legal steps are necessary, including, for example, asking for a meeting and having a lawyer present. Judicial review is a process whereby a person can go to a court and ask the court to look at a decision that has been taken by an administrative body. The court, when it's looking at that decision, is not looking at the substantive decision, i.e., was it a good decision, was it a bad decision? What they're looking at is whether or not the decision was taken in accordance with proper procedures. So the court will examine the procedures that the body used when they were taking that decision, and they will decide whether or not those procedures have been observed. If the procedures haven't been observed, then the court will generally, although not always, send the decision back to the decision-making body and tell them to go and make the decision again, but this time in accordance with proper procedures. They won't tell the decision-making body, for example, you chose the wrong SME when you were giving that contract out, you've got to give it to SME A instead of SME B. In other words, they won't substitute their decision for that of the decision-making body. They'll just send it back and tell them to do it again properly. So the Freedom of Information Act, in my view, is a very useful tool for SMEs if they have a concern about the way a contract is awarded. It lets them get the basic documentation to see what happened in the process, to see whether there has in fact been a possible breach of the procurement directives. At that stage they can go to their lawyer, and it's only then the legal fees start to run up. The lawyer can then advise them whether they have a decent case and whether it is worth getting engaged in litigation at that stage. However, there is a problem possibly with the Freedom of Information Act, and it's this. The Irish courts have said that if you have a challenge to a procurement decision, you've got to bring that challenge quickly. So anybody who is using the Freedom of Information Act to get documentation should do so immediately the decision has been made, because the Freedom of Information Act itself has time limits within which a response may be given. And it might be that the time it takes to get those documents will mean that a SME who then wants to bring a case before the courts is in trouble in relation to the time limits for bringing a case. So anybody who's thinking about getting information under the Freedom of Information Act should look very carefully at how long it'll take them to get that information and whether they can wait that long to bring a case. The one other area I would see the Freedom of Information Act being really useful is in relation to whether or not a public body actually should have got involved in a procurement contest. Some public bodies, in my view, might not necessarily realise that they are exceeding the thresholds when they are giving, for example, a services or a goods contract, and therefore they never put it out to procurement. If you use the Freedom of Information Act, you will be able to see how much the contract was worth that was awarded without a procurement process, and therefore will be able to challenge the fact that a public body didn't in fact get involved in a procurement process. So it's useful both if you think the procurement process has gone wrong, but also if you think that there ought to have been a procurement process and there wasn't.